Guys, I'm extremely sorry. I think I did a mistake on clicking somewhere, then it suddenly end the meeting. Okay. Mm, I was just trying to move to my laptop, my PC, then suddenly I turned off in my phone, so that I'm sorry. So I think, Fina, you can continue. What was your last statement about the example?
Sorry, ma'am. I couldn't hear you because my connection is bad. It's unstable right now.
Oh, right now
Or,
you can
but
hear me?
maybe the example is contractual break. Yeah. Maybe the example of the contract is kontrak jual beli, ma'am. Kontrak jual beli rumah gitu, ma'am. It's okay.
Um,
Oh,
it's okay, okay, that be part of the example, but okay. What I'm actually asking for you guys is probably you can show for the other groups, yeah. Probably you can show any kind of the real example, just like in last meeting I show you on how the franchise agreement would be, and probably some sentences on the franchise agreement, and yeah, something like that. So that would be, I think, uh, some additional information that the other groups who have not been uh, presenting your presentation, you can prepare that example. So for now, my headphone is not working. So for now, I'm gonna take Fina's presentation again, so you can see the presentation. It's a legal contract which is talking about sale of goods. And sale of goods is, I think it's the easiest contract ever. Because, well, yeah, it's just something about sell and purchase. And we're going to have another contract which is in, it's a little bit almost like sale of goods, but what is it called? Um, Production sharing. Oh no. So there are several kinds of sale of goods, guys. It could be something which is the sale of goods where uh, it just happened in one time. So after the transfer of ownership from the party, from one party to another party, then the contract has done. But there are some other more complicated one of the sale of goods contract. And here are some examples, some explanation from Finas and Daisy's group, which is there are several kinds of sell and purchase agreement, and what is the term in Bahasa of trial, sale, and purchase? Do you have any idea? What is the term in Bahasa of trial, sale, and purchase? What do you mean by trial, sale, and purchase? Vina, Desi, or the other team?
Apa ya, jual beli percobaan, jual beli dengan gimana? Coba-coba.
Dengan coba-coba. So it's not like iklan minyak ya, where it cannot be coba-coba, terutama for anak. Well, yeah. Trial, sell, and purchase. It is known in the Indonesian Civil Code as jual beli percobaan. I believe the term in bahasa is jual beli percobaan. And then we have sell and purchase with down payment. So you pay some amount of money at the very first beginning before the actual sell and purchase is coming to exist. And we also have this sell and purchase with example. So there are many kinds of sell and purchase. The point of sell and purchase is there is a transfer of ownership of the goods, because this is talking about the goods. But here I cannot find the definition of goods. What do you mean by goods? What are included as the goods? What is goods in Bahasa? Guys?
Barang, ma'am.
Barang. Exactly. What are included as barang? What
Barang
is it?
bergerak.
Only tangible goods, intangible goods? Is there any kind of intangible goods?
Yes, ma'am. Intangible
Tanah
good. Intangible.
What do you know tangible and intangible?
Tampak dan tan tampak.
Yeah,
Like
yeah,
haki,
it's
ma'am.
in bahasa barang
IPR, IPR,
IPR. Is IPR included as the goods?
intangible
What is
goods.
this? What? Sorry?
Intangible goods.
Intangible goods. Okay, so there are many kinds of you know types of goods. There are tangible goods, intangible ones, and then there are also the movable things and immovable one. But uh, but here is the thing that I cannot find from your explanation is what kind of goods that could be part of the sale of goods. Is that any kind of goods, like tangible goods or intangible ones? So yeah. Well, but basically, sale of goods contract covers more on the tangible goods one, that you can see the things, you can see the goods, what are the goods, but there are also intangible goods one, but it is there might be a special contract that covers the sell and purchase of intangible goods, just like there was an interesting case which was happened in the Netherlands about electricity, on how the the definition of goods is becomes broader from the very limited goods of tangible ones to something like we can see as an electricity, which is at some point electricity is regarded as goods. But then come back again to the contract itself. So we're talking about the contract, yeah. Uh, Yes, if it's a sale of goods contract, so the parties are the seller and buyer. So the most common parties in a sale and purchase contract are the uh, seller and buyer. But then usually, if you still remember my presentation last week, about the structure of contracts. So it is very important to put the title, the heading of the contract. So what is the heading? What is the title? What the contract means of? What kind of sell and purchase contract? It is sell and purchase of the car, sell and purchase of the house. So you should put the heading at the very first place. And then yeah, the form is free because we have the principle of freedom of contract. So it is whatever the contract is, but the most important is that there is a consent. There are consents from the parties. And here's the consensual agreement. What about the guarantee? What do you mean by guarantee? sorry. What do you mean by guarantee here? Fina or Daisy? What do you mean by guarantee here?
Explain, ma'am, but
Sorry?
ma'am,
What?
berisik ya, ma'am, di minyak saya.
No, 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 no. I
No?
can't hear you. No.
Nah, kalau di I'm sorry, ma'am, I use Indonesia. Maksudnya garansi itu gini, ma'am. Kan penjualnya kan ngasih, banyak penjualnya kan jual barang. Nah, si penjual tuh harus ada banyak kayak garansi, kayak apa, bisa jamin gitu loh, ma'am, kalau oh barangnya tuh bagus dan barangnya sesuai yang dia jual kayak gitu loh, ma'am. Misalnya nanti enggak sesuai apa yang dia jual dan dia tawarkan, kan berarti kan tidak sesuai gitu loh, ma'am. Jadi nanti itu tuh bisa masuk ke kontestasi juga gitu, ma'am. Kalau di aku bacanya kayak gitu, ma'am.
Okay. But what do you mean by this sentence? The seller must be responsible for the sale of goods sold by the court.
Ya,
What do you mean by the court? What do you mean
ya.
goods sold by the court? And
Hah?
because the sale was process that was defeated in the trial and sold were confiscated, what does it mean?
Ma'am.
Sorry?
Nah, eh, sebenarnya saya juga masih bingung di situ, ma'am.
Okay,
Or
so
maybe
if you say that the sale of
itu
goods sold,
saya
sorry?
saya salah masukin. Kayaknya ini tuh, nah, kayaknya ini tuh saya salah masukin, ma'am. Kayaknya ini tuh awalnya tuh nggak mau tak masukin kan, tapi mungkin kemasukin. Nggak apa-apa sih, ma'am. Ya, salah sih, ma'am. Tapi saya juga bingung di situ, ma'am, di eksekutif sale. Kalau di sini tuh ngomongnya penjualan eksekutorial.
Yeah, it's a cultural sale. So that is correlated with the sale and purchase of a confiscated goods. That in the court where somehow there is an execution decision, like where it involves any kind of confiscation. A party asked for the court for a confiscation. You know confiscation, sita jaminan. So where the party is asking for this confiscation, and then the court grant for the confiscation, and then after the decision has the legal power, then the court can do its lelang, so it's executed to sold by the court. I think that is the point here. So it is the sale of confiscated goods, isn't it? And then covering the hidden defects, the defect in question is defect in goods. Okay, this is also important in that these two sentences are what has been explained by Fina about that the seller shall guarantee that the goods are qualified enough or at least as what has been agreed, because if the seller cannot guarantee and the seller has breached the agreement on the goods should be like in this level, but the actual goods are not in that level, so it probably in this level of the quality, so it is already a breach of contract. So this is very important for the seller. And then we have some kinds of elements of sale and purchase agreement here, and we can see and yeah, here the main elements in the sale and purchase agreement are goods and prices. So if you still remember that we have discussed about the structure, we have heading, and then we have the parties, and then we have the operative part, and we have the main part, and goods and prices are the most and the core of a sell and purchase or a sale of goods agreement. So what are the goods? What kind of goods is it? And in some cases, there are several types. So the types should be clear enough about what kind of types that becomes the core of the agreement, and the prices, how much the price is. And then, okay, okay, and then we have this one. The coverage in the selling agreement that is must be considered. Okay, quantity, quality, price, shipment date. Okay, shipment date as well. So if it's correlated with, or especially international contract of sale of goods, especially in export and import contract, a shipment date is very important because it correlates with how the goods would be transferred into the buyer, and when does the transfer of ownership happen or take into account, and payment methods and technical requirements. I'm gonna show you a little bit example that I think I have already uploaded in the Google Drive. Have you guys seen?
Not yet, ma'am.
Not yet, ma'am.
Not yet. Okay. Would you please wait a second? I'm opening. So in last week, I've shown you about the franchise agreement. So just a little bit example that I get from a franchise website, and I think that's a relevant example. Now I'm gonna show you. Can you guys see now?
I still cannot see it, ma'am.
Now
Okay.
you can see
Okay,
it.
ma'am.
Oh,
Okay.
okay, ma'am.
Okay, here are several example or model contracts for small firms. Because I think now the government is trying to push the export and import activity. Sorry, export activity of the small firms, small and medium enterprises, which is in bahasa you hear it as UKM, usaha mikro kecil and probably menengah. So we have several examples that I got from it's already in 2010. I believe that there might be the recent one, like the more recent example of this trade model. But I think at some point it's still relevant just to show you on how the contract of sale of goods should be. So here's in chapter 3, international commercial sale of goods, and we have the short version and we have the standard version. The short version is actually the one which covers at least some important points in 37. Okay. Here. Chapter 3, International Commercial Sale of Goods. So here's some example of the sale of goods contract or model. And here again we have the heading, So this is important. What kind of contract it is? So is it in a sale of goods of what? Of, I don't know, maybe um, of, let's say, car or laptops, phone. That's for electronic things. And probably we have also like furniture. It's also common for any export and import activity. And then here is the parties, the comparison. We have the seller. You should put the name, the legal form, whether it is a limited liability company or whether it is only it is not a legal body. Probably it's partnership. It's a kind of CFI, Commanditaire Vennootschap, or a firm. Yeah, you should put it here. And then we have buyer. Who is the buyer? So you should put it clear in this part, and yeah, here and after as the parties. And um, in a common structure, we have some part which is before the main part. We have the part where it shows on uh, the recitals. Do you guys remember what recitals is? So it's like the background of agreement. But here we don't see it. But usually a contract needs recitals like the background of the buyer and the background of the seller, and why do they enter into agreement, this kind of agreement. So first thing first, as Fina said before, and Desi also said, that the most important in a sell of goods contract is the goods. So we have the first one is the goods. So you can see on how it tries to define the goods, which is something that the seller shall deliver the goods. And then the description, we can see the total quantity, and then whether the transfer would be in installment. You know installment? What is installment? Do you guys know it?
Um, Pemasangan.
Nope. In this regard, it is like when the seller transfer the goods in periodically, probably in 3 months, once in 3 months, or probably in some times. Jadi pengirimannya itu bertahap, let's say. So the first delivery would be in January, and the second delivery would be on June, for instance. So if it's that's why it there is if appropriate here. And then we have the percentage, if any appropriate, and then yeah. So this is the most important, that we have the quantity of the goods. Well, usually they also put the, let's say, the quality. So what kind of type of the goods is, whether it is the type A with the 50% of quality, or the type B with the 35% of quality, for instance. Yeah, it's just an example, because the main content of the contract is really depend on the parties. And then we have delivery, as Vina said before. So how the seller would transfer. If it's just a sell of goods contract, in a very a simple way, just like maybe Fina sells some chicken, some chicken to me, and then I order Fina for some amount of chicken, um, let's say 1,000 kilograms. So it would be 1 ton of the chicken. And then I asked Fina, and then we have such kind of of goods agreement. But that's very simple because Fina is living in Bantul and I live in Sleman, so the delivery would be very easy because Fina can just transfer the chicken by maybe a car or whatever that is easy. But if we're talking about import or export agreements, so the transfer would require shipment or probably a cargo with plane, let's say. You guys read the news about the ever given ship in the Suez Canal? Yeah, I think that's very important, and that's uh, affecting in any area of sell and purchase of goods, because that is one of the way, if we were driving a car or we're riding a motorbike, we have like a toll way, like the shortcut way. We have the shortcut way, and the Suez Canal and Panama Canal would be a shortcut for the ship to transfer some goods, because there are lots of ship bringing containers of goods, which is becomes the object of a certain sell and purchase contract. So this should be clear enough in this place. So where is the delivery, the address, the date, period, carrier, what is the ship, and then who is the company who becomes the carrier, and so on. And then the price is also important. The payment condition, how the buyer would pay the seller, whether they will use cash, check, bank, leasing, or whatever. As again, if it's a simple agreement, just like I buy from Fina some amount of chicken, then I could just pay it in cash or probably transfer via bank. But if it's an import or export, this one should be clear. And we have another method of payment. We have blockchain as well, that somehow it could be one of the method of payment. And then, yeah, it should be clear, and the documents. So if you transfer mm, the sale of goods, and the goods are in the big amount of quantity, so you have to somehow provide this kind of documents. We have also, if you transfer the goods via shipment, you also need this kind of things: certificate of origin, certificate of inspection, and so on. And if it's correlated with the plans or maybe something which probably will cause or will bring any virus or something like that, so be it has to be inspected before, and then the authorities will issue the certificate of inspection. And then here are some other importance where the buyer um, the buyer failed to perform the obligation. So that's why it is said as non-performance of buyer's obligation. And then we also have the non-performance of the seller's obligation. To what? To deliver the goods, and the buyer is to pay the price. So these are the basic obligation of the buyer and seller. The buyer shall pay the price, and the seller shall deliver the goods. So these are some fine, like when they are failed to perform the obligation, they have to pay some amount of fine. Or here they use the liquidated damages. And yeah, some contract has some contract have a different terminology. And then lack of conformity. And then this one, the buyer shall examine the goods. So uh, in this regard, the buyer shall examined whether the goods is the one which is what the buyer wants and not or not. And then transfer of property. So where is actually the property has been transferred, or when the uh, ownership, or when the transfer of ownership comes into account. And then avoidance of contract is just in some. And here, force majeure. This is very important for a certain contract to input a force majeure, because it's gonna be a long debate if we're talking about whether COVID-19 pandemic is part of the force majeure or not, because at some point it is at, some experts says that COVID-19 pandemic is um, a force majeure, but some experts say it's not. So you should put it clear on what are condition that is considered as force majeure. I think this is important not only in sale of goods contract, but in any contracts. Force majeure is an important part, because this becomes the one that you can claim for your non-performance of your obligation, because it exists a force majeure. And then if you guys have, or if the parties have the previous or any other contract which has been previously signed by the party, then whether this contract should be the first one to be applied, and then notices. And then yeah, dispute resolution is also is important, as you guys already learned about Indonesian private law, yeah, sorry, international private law, or private international law, sorry. So if you guys already learned that, I think this is also you guys can understand why this is important about dispute resolution procedure, because once the party is facing like a dispute, then they can just go to this article on how and where to settle the dispute. And then applicable law, what is the applicable law? If the party already becomes the parties, if the party or the parties coming from the state who already becomes the member of UNITROA convention, then I think uh, the parties have some kind of guidance or model. And then here the date, signature, the seller, buyer. And then we also, okay, this one is the short version, but there's also the standard version, which is way a little bit longer. What makes it different? I think lack of conformity. And then we also have this one, expertise procedure. Yeah, it's just on how the claim of the buyer could be conducted, like the technical matter, the transfer of properties. I think it's a little bit in more complete one. Restitution. Okay, this is different with the short version. So what kind of restitution that the parties can claim, or any party can claim when there is a damages or the loss. And then the damages, what is the damage, and what happens when the party suffering damages, and what the party can do when they suffering damages, you can put it here. And then mitigation of harm, once there is a harm, then what you have to do, what the party has to do. And then your hardship, uh, some people say that hardship and force majeure are two similar things, but some say it's different, because hardship is way more of the changes of circumstances. So yeah, they put it here on two different articles. Here is the change of circumstances, and here we have the force majeure, and then we have the just same like before entire agreement and so on. Okay, authorizations when the party agreed to make the contract to be more having an authorizations, then yeah, okay. Those are an example that you can see the sell and purchase or sale of goods contract. But here we also have long-term supply of goods. So what makes it different? The long-term supply is usually related to the manufacturer's goods between the supplier and consumer. So this is way more uh, about goods which is part of the manufacturer. But this one is just it could be any general goods. So this is somehow different. So those are my explanation, guys. If you have any question, please just give your statement now. Do you have any questions about the sale of goods contract? Oh, you guys still with me?
Yes, ma'am.
Yeah. Rizal, do you have any question?
Um, to be honest, I have a lot of question.
Oh, please. If you think that the time is not enough to ask in the Zoom, you can just ask via WhatsApp group. You can just split the tea in the WhatsApp group. It's okay.
Okay, ma'am.
Or you can tell me now, it's okay. We still have 3 minutes, isn't it?
Um, um, uh, what's the different like hardship and force major in the construction met? The basic difference of both of them, hardship and force major.
Okay. Well, usually in the hardship, it is something that the party can actually still fulfill the performance. So the party can still conducting their obligation, but probably being late because of there is a changes of circumstances. And in that kind of fact, in that kind of hardship, the parties can consult each other on how to settle this kind of changes of circumstances. But in force majeure, somehow the force majeure can really cut the activity of both parties. Like, let's say, the earthquake or the flood, and the flood make the object of the contract to be gone or maybe distracted, and then on that kind of condition it could be it could be stated as whether it is a hardship or whether it is a force majeure. Depends on whether the parties can actually still fulfill the obligation, but it's just a matter of they might be late or they might be cannot fulfill the obligation as um, as has been limited on the certain time of the agreement. So can you get it?
Mhm. And not yet, ma'am.
So
Like
hardship,
pandemic.
that's the thing that I'm saying before, that the pandemic becomes a very uh, long debate on whether it is a force majeure or hardship. But again, it depends on the contract, and it depends on the party on how to define whether it is a hardship or force majeure. But the point is, where it is a hardship, the party can the parties actually can still fulfill the obligation, but it's just the matter of the parties cannot fulfill it on time, let's say. Or probably there is some changes of circumstances, whether faced by the buyer or seller, that it makes them cannot, let's say if it's a buyer, then it makes the buyer cannot send or cannot transfer the money to the seller. Let's say, for instance, because of flood, there is a flood, and then the buyer lost his money, all of the cash money, but he still has some amount of money in the bank, but and then he still wants to pay the money, pay the buyer, sorry, pay the seller via bank, but it would make him to be late to pay to pay the the goods to the seller. So at some point it could be regarded as the hardship of or the change of circumstances. So that's why in this example it is stated that, okay, so in that kind of condition the parties can ask or can request for, let's say, for revision or additional information or additional agreement of the contract. But here it should be it should fulfill this kind of condition. Let's say the event could not reasonably have been taken into account by the affected party at the time of conclusion. So the event are not happening when the parties enter into this contract, or the events are beyond the control of the affected party, or the risk of the event is not one which the party affected should be required to bear, or each party shall in good faith consider any proposed revision. So these are just an example on how the hardship uh, can be one of the media for the parties to request for additional or for revision of the contract. So that is result. It is a hardship. But force majeure is something that really make the parties for not be able to conduct their performance or obligation. It's really in any way cannot be reversed, cannot be changed, cannot be revised just by any revision, just like hardship. You can see here war, emergency, accident, fire, earthquake, whatever it is. And then other impediment which affected party proves was beyond control and it could not reasonably expected to have. And then uh, yeah, and then they are the parties who really cannot uh, implement their obligation, but they are not regarded as someone who breached the contract.
Ma'am.
Yeah.
So even like earthquake, like flood, if this is possible to fulfill the obligation, it's include to hardship, right?
Yeah, it really depends on the contract and the goods or the object of the contract result. So uh, somehow we put the earthquake, flood, or war or whatever to be the first mayor. But again, we have to put the context on the contract, because let's say it could be not all of the contract would be affected by this kind of condition, right? Let's say, okay, there is an earthquake, there is a fire, but your object of the contract are not affected by this kind of earthquake. So you can fulfill the contract or the obligation. It's just your excuse to say that there is an earthquake or flood. So again, it depends on the contract and it depends on the object of the contract.
Okay, ma'am.
Yeah. Okay. Any more question? Or if you guys have a question, you can please mention the question in WhatsApp group. I think we already running out of time because it's 10:30 already. But still, if you guys have any question, just please let me know. And thank you, Fina. Thank you, Desi. Thank you, Rizal, for the question and for the presentations. Should you have any queries, again, please say it in group WhatsApp. And now, please just close our meeting by reciting Hamdalah together.
Alhamdulillahirrabbilalamin.
Alhamdulillah Rabbil Alamin. Thank you, and let me close the meeting first. Yeah,
Thank you, ma'am.
and see you.